Hi, my name is Scott Lewis. I'm one of the partners with the NCRM Group and co-founder and advisory board member of ATIXA and NBITA. And I'm here with
Sonny Schuster, and welcome to our training session. I'm also a partner with the NCRM Group, one of the founding members of ATIXA, and I also serve on the advisory board of both ATIXA and NBITA.
So the title for today's session is Analyzing and Making a Finding and Using the Preponderance Standard. We're going to focus a little bit broader than that. We're actually going to talk about why the preponderance standard, as well as what the preponderance standard, and look at some other standards of proof that exist. I want to start by saying really quickly that we're saying standards of proof, not burdens of proof. And in Title IX, civil rights based, and I would make the argument, all types of non-adversarial disciplinary proceedings, which I think they should be, we talk about standards, either the evidence meets the standard or it doesn't, as opposed to somebody having a burden to overcome, which we find in the criminal and civil justice systems. Sonny, what are the other standards and why do they exist?
Sure. I think it's important when we're talking about the preponderance of the evidence standard that we do so within context of other standards that are most commonly applied. Of course, typically the next standard up is identified as clear and convincing evidence. Interestingly enough, although it's gained popularity in terms recently, it's not used that frequently, certainly not used in either criminal or civil court. But then the highest standard is the standard when Scott was talking about a burden. The standard that in a criminal action that the prosecutor or district attorney or whatever law has to apply proof beyond a reasonable doubt, so that an individual accused of a crime is considered innocent until proven guilty. Common terminology that we apply, but Scott and I are going to spend time talking about the applicability of it with the preponderance of the evidence standard being the most common. And talk a little bit about the application of preponderance. What does it mean? What does it look like?
Yeah, I like to think about it on a continuum. And you know, when you talk about, I love that idea, like why those different standards are. Let's own for a minute in our systems, particularly in student-based conduct systems, the reason we have those different standards is because of what's at stake. Mm-hmm. You know, when Sonny talks about that idea of beyond a reasonable doubt in a criminal system, it's because your life and liberty are legitimately at stake. You might go to jail or be put to death. That's huge. Not being allowed to go to a particular school seems to pale by comparison.
Absolutely.
You know, not everyone even goes to college. So I think about these standards, though, like a line, like a continuum. And so you have on one end of the continuum, there's, I guess, for your purposes, it will be on this side. One end of the continuum, you have no evidence whatsoever. And on the other end, think beyond a reasonable doubt. I like to think of it as overwhelming evidence. Remember that our process is administrative, and we're talking not to lawyers in court, we're talking to students and employees and their advisors who may or may not have any legal training whatsoever. I kind of like to steer away from those legal terms. So I think about no evidence or a misapplication or misunderstanding of policy, insufficient evidence kind of moving along. Then you have the preponderance, or something is more likely than not. Mm-hmm. It's that right in the middle, but just past it would be responsible, and just this side would be not responsible. That middle one is where the arguments start to happen. Then you have clear and convincing a little bit further down the way that I heard one legal scholar refer to as 75% sure, which I thought was interesting. And then way down here, beyond a reasonable doubt or overwhelming evidence. Even in clear and convincing, I tend to use the term very sufficient evidence. You know, there's more there than just a little bit past the line. And I think that's a helpful conversation. I'm not sure it's helpful as a standard that has to be met.
I agree. I mean, I heard one administrator say, I have to be clearly convinced. So it was like, that's an interesting application of the standard.
You're clearly reading things.
Yeah. And so when we're talking about preponderance of the evidence, and I think the identifying it where it lives on that threshold or on the continuum is an important one, particularly that if it is exactly 50-50, there's not a finding of responsibility. Right. And so what does that mean? What does it look like? How is it applied?
Yeah, the tie goes to the runner. I mean, that's kind of what it is. And I think what's interesting, I struggle because I've heard us say the issue of like a feather. This idea of 50 plus just that little bit. But a feather seems so light.
It does. It seems.
You think about that scales of justice, and there they are in the middle. I think if I put a feather on one, it might not move.
Might not move at all.
It might not be sufficiently heavy. And so there is this notion of a little bit more than just 50 plus a feather.
And a little stone, 50% a little stone.
But that stone is a weighted piece of evidence.
It is.
It's something you can put your hat on and say, that was the piece that moved me past.
Absolutely.
That got me to this side. What about clear and convincing, though, as you start moving toward it? You use the term gaining popularity. Certainly, we've had schools, and let me be clear, you said it spot on, not many. It is
very, very few.
Very, very few civil and criminal processes use it, much less schools.
Oh, absolutely. Gaining popularity in governmental circles as they're talking about imposing differential standard. Where we see it most popular, of course, is in honoring the American Association of University Professors standards as it relates to a tenured faculty member. And I want to go back to what you were talking about with the various standards are responsive to what's at stake, what's at risk. And so the AAUP's argument in using clear and convincing is that in order to achieve tenure, it's a substantial process. So losing that has a greater impact on the individual than merely losing a job, for example, because of what it takes to get there. So that's why they hold very firm that clear and convincing should be the standard to remove a tenured faculty member.
Yeah.
That's where it's most commonly used in colleges and universities.
But yet in the non-college university world, it takes a lot of time to become the chief financial officer of a major corporation, but they don't change the standard.
Absolutely.
The administrative rule of law there is still preponderance.
Still preponderance.
But I think one of the things that happens, Sonny, is the more those stakes go up, and I don't know the citation, but if you contact us, we'll find it. The research on jurors when making determinations and the stakes have gone up, when somebody's going to prison for life, when somebody's about put to death, and they're using the beyond a reasonable doubt. Some of them actually talk about how they're like beyond any doubt. I need to be 100% sure. I think that same thing happens in our process. When we're talking about severe sexual misconduct like sexual assault, high end of contact like groping, things that will be career ending, either for expulsion or suspension, I think that same things apply. When I talk with panels, J boards, if you will, that make these decisions, they're always like your guy, I need to be clearly convinced. They know the standard's preponderance, but they're thinking to themselves, man, before I'm going to end this kid's academic career, this guy's academic career, this gal's academic career, or their actual career, I want to be a little more than that feather. Yeah. In fact, I want to be more than just that little stone.
Yeah.
It's that inherent bias for us that when a lot's on the line, do you worry at all that if a school were to move to clear and convincing, that it's going to be, now I need to be more than clearly convinced?
I do worry about that. I worry about the fact that just articulating a standard that appears to be a different standard, and you talked about standard of evidence, not burden of proof, and I think that's such a critical concept because when there is a burden, a party must overcome that burden with evidence. When we think about the scales for criminal, so a person right here is found or is presumed innocent. The burden is on the justice system to pile enough evidence not to come here, but to bring that person up here.
Right.
And so the same kind of concept in a lesser dramatic way is going to apply with clear and convincing, and that is the burden rests. And what makes me concerned is that when an institution is applying a clear and convincing evidence standard, and frankly, there's lots of different elements of it that give me concern, but one of the concerns is by its nature, there is a disparity between the amount of evidence that needs to be collected for the two parties to meet a standard. we call that the burden that you spoke about early on, that is basically unacceptable in an equitable process. And so I fear that our college administrators will move in the direction of becoming prosecutorial, that will move away from gathering evidence equitably and will instead work on building a case because they have to overcome that. So when we think about equitable as it relates to preponderance, what are the elements or issues that that you see evident or important?
Yeah, I think that you hit it spot on. This idea of once we move beyond, and again, I worry because I feel like in the minds of these adjudicators, they're already a little beyond. That it's no longer both sides. If you think about it as adversarial, you have the reporting party and the responding party, and when it's in the middle, when the standard is dead center, it could go either way, and that's equitable. It could be 55%, it could be 45%, but it's equitable. That once you shift it higher, I think you're spot on, right? That you're gonna potentially find some Title IX officers who are feeling like, I have to find more, which is not the place we want them to be. I want them to be exactly where they are now, which is I have found all I can find. And actually, sometimes we do find sufficient evidence that goes into that, as I put it, very sufficient evidence category, where you end up talking to a responding party, and I'm pretty upfront with them, and I say, I draw my continuum line, the chart that we have on the slide for you, and say, gosh, I'm looking at it with my co-investigator on this allegation, we're here.
Yeah.
And I'm struggling. And I've actually said, like, beyond that moment, I'm like, I can't see how a reasonable person could not find this responsible.
Yep.
Help me understand why you think it's not. And a lot of times the respondents are saying, I can definitely see it on that one. But on this other one, maybe we're not there either, and that's fine. But if we have to keep getting past a point, I think it's inequitable to the reporting parties. And honestly, my concern is it'll bring a chilling effect.
Yeah,
I don't think there's enough, so why bother?
And one of the important lessons related to this when we're using a preponderance is, number one, understanding it. Understanding, you used a comment, when you've gathered everything that's out there, when there's no additional facts to be learned. Two things continue to concern me because I want to make sure schools get it right. One is documentation of the facts and analysis of the facts, pulling in and understanding how to apply credibility issues. But the next piece is articulation of it. Because frankly, I think that's what's getting schools in trouble. They're following their gut or they're following their heart, and they're not following the documentation of the issues because they've either failed to document it adequately or they failed to analyze it adequately.
Right. So when you're making that finding, it's not just saying the old circular student conduct letter that existed forever, where it was, we found you responsible because we determined by a preponderance that you're responsible,
Absolutely.
which is a zero argument.
Right.
It needs to have that. Here are the pieces of evidence that were very determinative, and one of those, I think you mentioned it, but it has so heavy a weight, is credibility.
Absolutely.
We found these statements to lack credibility, or we found these statements to have more credibility. So that was the piece of evidence that pushed us beyond the preponderance, or that lack of credibility kept us from getting to the preponderance.
Yeah, and it's not sufficient to say I found this party more credible than that party. It's what you were saying. These are the elements that supported either the questioning related to credibility. And what I always encourage is, if you've got questions that suggest this party may not be credible, that A, you can articulate why, and B, you demonstrate how you went after additional evidence to support that or to verify that. Is it just a misunderstanding? Are you anticipating based on their body language? So it's not sufficient to feel that someone is less credible or more credible, but that documentation of what were the elements that supported that.
Absolutely. And that we've been legislated now into rationale. There's been no option.
That's right.
And so that was the warning shot across the bow of no more going with your gut or your heart.
Right.
You've got to tell everybody
right.
how you came to this conclusion. And that's how you're going to get to that 50.1% or
Right.
55% or whatever it is, or not get there, and explain why. And this is the part, I think, in the making that finding, some of our investigators and administrators and boards have shied away from it because nobody wants to call somebody a liar. Like nobody wants to put their name on that thing that says this person is a sexual assaulter.
Yeah, absolutely.
But that's what we signed up for. And so ultimately you have to do it. But you should feel good about it because you say, this is where the standard is. This is what didn't get to this point, or this is what got me past that point. And I feel strongly about it, so strongly, in fact, that I can articulate why and make it not arguable.
I agree. One other thing that I want to mention, of course, full disclosure, Scott and I are both lawyers, but far too many campus counsel have been for years advising their student conduct or their Title IX investigator clients don't develop the rationale and articulate it in writing because you're laying out the vulnerability. You really got to fight against that because that's what's actually going to provide the appropriate documentation for the decision process.
Right. If you don't tell them how you made the decision, they get to imagine how you made it.
Absolutely, yes.
And I can imagine quite a bit.
I can too.
Imagine bias. I can imagine prejudice.
Yep.
I can imagine that you just like this other person more. There's all sorts of things. I can imagine you hinged it on a piece of evidence that I can completely discredit.
That's right.
And that's not what we want.
Right.
And so Sonny's spot on in that we've got to move more toward that world of we feel very comfortable with this decision and here's
why. The here's why, from my standpoint, is the linchpin in it. You've done a good job of gathering and now you analyze it and it's the here's why.
Yeah. So applying the preponderance standard, if you want to shift your standard, the sort of what that might look like and why you might not want to do it in an equitable civil rights model, those are some of the high points. That rationale, so critical to all of this. Thank you all for taking the time to watch this. We have scratched the surface on a much larger topic that we could spend more and more time discussing. We hope this has given you some good, valuable insights. Sonny, you have anything you want to add at the very end?
No, other than I think visually applying the continuum when you're working with an individual and you see where you've reached it is another critical piece that will serve you well when you're identifying that to parties.